Hey everybody, Matt Johnston here with the Johnston Business Law Group, and we are going to be talking a little bit about independent contractors and some recent developments that could have an impact on how independent contractors are classified as either independent contractors or as employees. Before we get started, I really would appreciate it if you would hit the subscribe button that you see down there below. Also, if you click the bell, you'll get a notice when we have new content available. So the setting for this particular case is a federal court is a federal hearing in the National Labor Relations Board out in California. They filed a claim against a company out there that does shipping, logistics, and things like that, in which the National Labor Relations Board alleges that the business in question is misclassifying its drivers as independent contractors when in fact they should be employees. Now, disputes over misclassification employees happen all the time. And in fact, the larger concern for this particular claim is that it looks like it is aimed at undermining or overturning a decision that was made back in 2019 that was done by the National Labor Relations Board and considered pretty friendly towards the idea of having independent contractor status. So, what am I really talking about? Well, in a number of times I have spoken about independent contractors and the misclassification of independent contractors, and I often use the Department of Labor test. But here's the problem with independent contractor analysis. It could be that a person could be eligible as an independent contractor under one law, but not under another law. So things get a little bit dicey, and that's why you have to really think hard and think long and hard about how you are classifying employees. So the National Labor Relations Board has its own 8-factor test that they use that was outlined in this 2019 case, and I kind of want to talk a little bit about that. So the first factor was the extent of the control by the business. Now this looks a lot like the same sort of test that the Internal Revenue Service uses, that state labor laws are using, as well as the Department of Labor. So that is, how much control over the means and methods of work does the employer have? The more control, obviously, the more likely you're going to have an employee. The less control, obviously, a little bit more independent contractor status. The next is the method of payment. Now, this is a bit unusual. This is not usually a factor that's considered by the IRS or by the Department of Labor, or, so far as I know, state agencies. But how independent contractors are being paid, or in this particular case back in 2019, it was a franchisee type of thing. So how were the independent contractors paying, and how were they being paid? The next up was what the National Labor Relations Board referred to as the Instrumentalities of Work. This is who's providing the tools. Most of the time in truly independent contractor drivers, they're using their own vehicles. Think Uber or Lyft, or an independent trucker who has his own truck. In other situations, the company that is, employing the people, they own the trucks, and then, the employees then use the trucks that are owned. So one of the factors that the National Labor Relations Board looked at was whether or not the driver was responsible for paying for gas, paying for repairs, things of that nature. All right. Next up was supervision. Now, this is a little bit like who's controlling the work. How much supervision is there provided? Now, I've often said that even when you are employing independent contractors, it's perfectly reasonable to have some level of supervision. After all, they're being hired to do a particular job. You want to ensure that they're doing that particular job. So you can have things like, we're going to have status meetings, and we're going to have conversations, and we're going to make sure that you're meeting your deadlines. That's all perfectly normal. But for whatever reason, the NLRB decided that they were going to have that be a separate factor to look at. Next up is the relationship that the parties created. Now, a number of times I have talked to people and said, Just because you have a contract that says a person is an independent contractor doesn't mean they actually are an independent contractor. So you do have to pay attention to what the parties want to do in terms of the relationship, but that's just one factor to look at. You can't look exclusively at what the parties say, because oftentimes there is an asymmetry in power and bargaining. And the more that asymmetry exists, the more that an agency is going to say, well, that looks more like an employment relationship rather than an independent contractor relationship. The next factor that the NLRB used was whether or not the workers' efforts were part of the employer's regular business. Now, this is often thought of as a factor, and I often say the closer to your core business that the worker is doing, the more likely it is you're going to have an employment relationship. The reason being is that everybody has a core business function. It is what they do. And the closer you are to having an independent contractor do that, the more likely you may have employees who are doing that work. And then you're getting into some sort of discrimination and you run into a whole series of problems. So my suggestion is the closer to the business, your core business that the independent contractor is doing, the more it looks like an employment relationship. The seventh factor of the 8 that the NLRB looked at was the length of employment. I often caution people that if you have long-term engagements with one person, a solo, you're starting to look an awful lot like an employment. And by long-term, it could be even 6 months might be long-term depending upon the nature of the work. You could also be looking at multiple years. So for example, I've worked with independent contractors who were retained basically on a semi-permanent basis, and their contract was just renewed without any renegotiation, without any sort of anything more than a summary look at. And these kinds of relationships tend to raise red flags with all of the agencies, from the NLRB to the IRS to the Department of Labor. And finally, the last one was the skills required. The more closely or the more unique the skills are, the more you might be able to justify an independent contractor status. But if the skills are pretty generic, if the skills are easily transferable, or that it's a low skill position or a no skill position, you're going to have a tough time making the argument that it is going to be a independent contractor relationship. Now, as I said at the beginning of this video, a lot of the NLRB's actions right now they're kind of speculative. We're not sure where the board is going to go, and it may decide that, well, we're going to go ahead and keep this test in place, and they may just find that the facts of the new case that's involved will look a little bit different. The NLRB is typically dealing with very, very specific fact-based complaints, and so the results may not matter. But I just wanted to take this opportunity to talk about this case because the NLRB does look at misclassification of workers differently than the Internal Revenue Service does and the Department of Labor does. So if you're trying to determine whether or not you're going to be using independent contractors or not using independent contractors or employees, you're going to have to look at a couple of different tests, and you really should engage some counsel. If you're not sure the people that you are hiring can be independent contractors, you really should speak to an attorney. How you doing? I happen to be one of those guys. And if you want to schedule a consultation with us, you can click on the link that you'll see down below in the show notes. In the meantime, I hope everybody's doing well. Go out and watch some live soccer. Bye-bye.